Basics of Employment Law. Introduction to the module. This module will teach you about the history of UK employment law and how it has evolved and changed many times over recent years. You will learn about its purpose and the importance of providing protection for both employees and employers. Topics to be covered in this module. What is employment law? Purpose the law serves. Individuals the law covers. Entity the law covers. What is employment law? Definition. Employers and employees need legal guidelines to ensure that neither is being exploited or deceived in the workplace, either by external parties or colleagues. That might seem a harsh statement to make, but it's an unfortunate truth. This is why the UK has employment law in place. But what is employment law? According to the Chartered Institute of Personnel and Development, the CIPD, the definition is: employment law regulates the relationship between employers and employees. It governs what employers can expect from employees, what employers can ask employees to do, and the employee's rights at work. In simple terms, it ensures that employees have their human rights upheld, are paid accordingly for their work, and are not asked to endanger themselves. It also ensures that employers have guidelines for what to realistically expect from workers, regulations for paid leave, and when staff may be dismissed for breaching their contracts. We'll explore this definition in more detail during the course. History of the employment law. The history of the employment law is dynamic and given to change driven by UK government policies and worker disputes. Before the 1980s, the balance between employers and employees was mostly dependent upon agreements based on the Master and Servant Act of 1867, which was designed to prevent employees from breaching contracts. However, the formation of workers' trade unions in the UK from 1871 onwards was a way of protecting employees from exploitation. When the Conservative government took power in 1979, they showcased a plan to minimise the power of trade unions. This led to legislation changes after the miners' strike of 1984 and 85. The Employment Rights Act 1996, or ERA, was passed in 1996 and was designed to move the power back from unions and directly into the individual employee. The Labour Party took control in 1997 and started legislation to bring UK law back in line with the Social Charter and the EU. This led to a national minimum wage being formally announced in 1998. In 2010, the UK coalition government, Conservatives and Liberal Democrats, made some changes, including some controversial amendments to the employment tribunal systems, and there are ongoing reviews that will affect employment law, including updated examinations of the balloting process for strikes and the Human Rights Act of 1998. The Brexit vote in 2016 to leave the EU will undoubtedly have implications for employment law in the UK when all details are finally settled. This demonstrates just how quickly and easily employment law has changed in modern times. Source of the law. Like any UK law and legislation, employment law is created, changed and amended in one of three ways. Number 1. Statute. This is an Act of Parliament that undergoes a long process to become current legislation. It starts as a green paper for consultation purposes. After being discussed and accepted in parliamentary committees, it becomes a white paper, or bill, which is a clear statement of policy. This is subjected to an agreement in the House of Commons and then the House of Lords. If passed, it then receives a royal assent and eventually UK law. This is the path that was taken by the National Minimum Wage Act 1998. Number 2. Codes of practice. Strictly speaking, these are not actually laws, but they are recognised by legal courts. If they are broken or breached, there will be criminal proceedings actioned against the perpetrator. The Highway Code is an excellent example of this. In terms of employment, they are governed by recognised public bodies such as ACAS, Advisory, Conciliation and Arbitration Service, and would cover such issues as unfair dismissal. Recent addition to the law. To understand the process of employment law, we can take a recent example of legislation change to understand the procedure further. This took the form of NMW, naming and shaming, and came into force via the stature process on the 6th of April 2020. This covers legislation regarding the treatment of businesses who do not comply with the National Minimum Wages, or NMW, laws. Recent addition to the law. To understand the process of employment law, we can take a recent example of legislation change to understand the procedure further. This took the form of NMW, naming and shaming, and came into force via the stature process on the 6th of April 2020. This covers legislation regarding the treatment of businesses who do not comply with the National Minimum Wages, or NMW, laws. It allows the government to publicly name and shame those businesses who have been identified as paying their employees less than the lawful minimum wage or owing more than £500 in arrears. The changes also included benefit options that made it easier for companies to conform to NMW restrictions. This was passed after the UK government was criticised when similar legislation was suspended in 2018. The new bill was formally announced by Parliament in the UK media on the 11th of February 2020. Further examples can be found on official government websites. Purpose the law serves. The role of the employment law is self-explanatory to a point. It is designed to protect the human rights of anybody involved in the employment process. This can be summarised in 3 simple statements. Employment law is enforced and governed to ensure that the relationship between an employee and an employer is regulated and fair on both sides. When employers and employees comply fully with employment law, then the workplace will be a reasonable and trustworthy place to work in. It will also ensure that necessary procedures such as hiring and firing will be actioned fairly and impartially. Following the guidelines and legislation in employment law will prevent discrimination and encourage equality in all areas of a business. Individuals the law covers. To further understand how employment law covers the entire workforce of a company, we can further define the following terms. Employee. In the most basic of definitions, an employee is someone who works under an employment contract. An employment contract is an agreement between an employer and employee that states the rights, duties, and responsibilities of the employee in their role. As most people accept or sign a contract when they accept a full-time job offer, this is the most formal indication that someone is classified as an employee. These will be discussed at further length in Module 3. An employee is automatically entitled to specific rights under UK law. These include such benefits as emergency leave, statutory redundancy pay, flexible working consideration, and minimum time given before being dismissed from a job. Other rights that indicate an individual is an employee can include paid holiday and annual leave, minimum hours of work expected to be worked, regular job attendance required at a workplace, workloads are defined by colleagues or agreements, entitlement to sick pay or maternity leave, access to a company pension scheme, companies provide utensils and equipment, disciplinary procedures can be applied, paperwork refers to a worker as employee. Employee shareholder. According to the UK government definition, an employee shareholder is someone who works under an employment contract and owns at least £2,000 worth of shares in the employer's company or parent company. So, the only real difference between an employee and an employee shareholder is substantial ownership of shares and interest in the company that they work for. This entitles the shareholder to redundancy consultation and the transfer of undertakings, or TUPE, which protects them if the business is bought by a new owner. Apart from that, the rights of an employee and employee shareholder are mostly the same. Apart from these differences regarding personal rights for a shareholder: statutory redundancy, no protection given; unfair dismissal, no protection apart from discrimination or safety reasons given; flexible working hours is not given, apart from the period after maternity leave; early return from maternity leave only allowed with 16 weeks' notice; extra training hours can be requested. Anybody should be able to apply for an employment shareholder job, and there are tax advantages and obligations, although tax relief was suspended after December 2016. For more details regarding employee shareholders, you can visit the gov.uk website. Worker. While the difference between a worker and an employee might seem somewhat confusing, it mostly comes down to contractual definitions. A worker is someone who undertakes a specific task for reward, as per agreement or work contract with an employer. This is not the same as a long-term binding employment contract and does not entitle the worker to the same set of regulations. However, as of 2020, individuals defined as workers must also now be given written statements regarding any work agreements when it was previously just employees who received one. The full rights given by an employee contract will be covered in the following module. The other circumstances that qualify an individual as a worker can include: they can promise to fulfill a task for a benefit instead of a cash sum. An employer is obliged to supply work for them while they are under contract. Their work is casual or irregular and can be referred to as 0 hours or freelance. They are under the direct supervision of a manager or director. They must agree to the terms and conditions of a business to be able to work there. However, they do not have the same legal rights that employees do for emergencies, redundancies, flexible working, and unfair dismissal. They do still have rights concerning minimum wage, holidays, and discrimination. A full description of a worker's rights and classification can be found at the gov.uk website. Self-employed. To be self-employed means that an individual is running their own business or charging a financial fee for their services, and therefore take full responsibility for their own finances as a result. They are not paid via payslips, but charge invoices to customers and clients. As a result, they do not share the same employment rights and protections that employees are given, although they still have health and safety cover along with non-discrimination rights. To be regarded as self-employed, an individual will usually have the option to take or decline assignments or pieces of work, hire others to do specific tasks for them for a fee, take responsibility for any work that has been poorly undertaken and expect repercussions, agrees on a price for the amount and rate of work beforehand, work for more than one customer at a time, finance their expenses and equipment. Self-employed individuals will also have to self-assess their annual earnings and pay tax bills directly to HMRC, or Her Majesty's Revenue and Customs. Entity the law covers. By entity, we're referring to a set of circumstances and situations that may arise under an employment contract, and ones that are legally covered by the legislation. This is a lengthy list, but the most commonly experienced issues revolve around employees and cases involving number of working hours in a set period, parental and maternity leave, discrimination based upon age, disability, race, religion, or gender alignment, bullying and harassment in the workplace, equality regarding wages and career prospects, redundancy entitlements, minimum wages paid in salaries, specific contents in an employment contract. There are many more examples that could be quoted, but this should give you a broad idea of the importance of employment law. Summary. In this module, we have covered the following points. Employment law is the regulation of the relationship between employers and employees. Several significant changes have been made to employment law in the UK since the 1980s. Employment law can be created or amended in one of three different ways. Significant legal differences exist between employees, workers, and self-employed individuals. Guidelines within employment law exist to ensure that neither employers nor employees have their fundamental human rights infringed.